Hello, I'm Upasana Dasgupta, and today it's my honor and pleasure to be presenting at the 2023 International Symposium on the Rule of Law in Outer Space. I am affiliated with Jindal Global Law School, OP Jindal Global University, Sonipat, India, where I teach subjects such as international law of outer space and international law and relations. I hold a PhD in aerospace law from McGill University. Today, I'll be speaking about megaconstellations and state responsibility. So, firstly, megaconstellations. What are they? Megaconstellations are constellations of satellites, such as hundreds and thousands of satellites, which have one big functionality. And many of the satellites that are being such constellations are being planned now. There are, for example, 190 constellations which are under progress. SpaceX's or the US's SpaceX's Starlink satellite, it plans to have more than 40,000 satellites. Starlink's first satellites was launched in 2019, and there are about 3,580 Starlink satellites on orbit. OneWeb has about 600 satellites which are on orbit. Similarly, in 2021, China filed that at ITU, the National Telecommunication Union, that it wishes to launch about 13,000 satellites, which would be called the Guowang or the national network, which would be providing broadband services and will give connectivity to remote areas. So these mega constellations are huge in number, but they're beneficial to Earth. For example, the Guowang constellation, it's going to connect the remote areas. So they have beneficial effects, and they are supposed to improve the life on Earth. So if that is the case, then there is a difference between these mega constellations which are serving a purpose and non-operational space debris. And often they are connected together, but then they should not be, because whereas space debris are redundant and not necessary, mega constellations, whether the launch of it should be regulated, whether there should be some conditions put is another question. But they are important and they are relevant for our space applications and space technology and its benefits on Earth. So we have to recognize that they are not non-operational objects, and we have to recognize that. So now that we have recognized that, we also have to realize that these numbers that they pose, right? The mega constellations pose create a problem. For example, I remember before any mega constellation was launched, in 2016, there were about 1,400 operational satellites. And today, if you look at the numbers, as for latest numbers, there are about 7,500 operational satellites. And many of them, much of it can be contributed to mega constellations. And remember, when we are talking about this, we are talking about a space that is already congested with space debris, and it is already competitive and congested, as has been said. So, and we have seen proof of that, right? For example, on 3rd December 2021, China filed a non-verbal to UNUSA detailing 2 instances where the Chinese crewed space station had to maneuver twice in 2021 to avoid collisions with Starlink satellites. Now, one of the big questions that comes is that what happens when these maneuvers have to be performed? Who bears the cost of it? These maneuvers are very expensive, to say the least, because maneuvers need fuel, and fuel is a limited resource for a space or for a satellite. If that is the case, then every time a satellite has to maneuver, it is using up its fuel and thus maybe reducing its life cycle. If that is the case, then there must be something done about the accidental collisions, the near collision events. And of course, one of the things that is being talked about, and that is generally what the mega constellation operators are saying, that we would reduce the number of years the satellites are on orbit after becoming non-operational, which is a great thing. But the question, one of the biggest questions, is who bears the responsibility for the maneuvers that have to be performed. Now, the question is that if we look at the note verbal that China had sent to UN, and it rightly pointed out that Article 6 of the Outer Space Treaty should be invoked. An Outer Space Treaty, Article 6, clearly states as follows, if I may read: state parties to the treaty shall bear international responsibility for national activities in outer space, including the moon and other celestial bodies, whether such activities are carried on by the governmental agencies or by non-governmental agencies, and for assuring that national activities are carried out in conformity with the provisions set forth in the present treaty. That's the first line of Article 6. It basically says that states are directly responsible for acts of their private parties, and they are, of course, responsible for the governmental acts. And remember that when we are talking about this is why it's important to talk about Article 6 here and not talk about liability, because liability, if we see Article 7 of the Outer Space Treaty, as well as the Liability Convention, it says that there has to be a damage that has occurred. Now, in case there is a maneuver and there's a near collision, and that's why there's a maneuver, there is probably no damage done, no physical damage has taken place, perhaps. So it may become difficult to claim under Liability Convention or even Article 7 of the Outer Space Treaty. But that does not stop one from claiming for maneuvers under Article 6 of the Outer Space Treaty. Because Outer Space Treaty, if you look at the Article 6, it basically talks of responsibility. And responsibility, and it changes the attribution of responsibility to say that even for acts of private parties, the state would be directly responsible. If that is the case, if we have to remember that is the case, that in this case, Article 6 it basically modifies the general international law on state responsibility, and which is is there in the Articles of State Responsibility, codified there. So the Articles of State Responsibility, if you look at it, there are two conditions under which a state can be held responsible. One, there has to be a wrongful act, international wrongful act committed by the state, and that act has to be attributed to the state. Now, attributability is made very easy under Article 6, and that's a condition that has been modified under Article 6 because that is a lex specialis, and that will prevail over the lex generalis. So that the attributability condition is only modified by Article 6, but Article 6 does not modify the other condition that is there in the Articles of State Responsibility, which is that a state is responsible if it commits a wrongful act. And it does not change the other things that flow from responsibility, which is basically because if you're responsible and you breach that responsibility, then you have to pay reparation. Now, what is reparation? Reparation is basically instituting a situation which would have been there before the harm was done. If that is the thing, then if someone is responsible to ensure that collision does not happen or a near collision event does not happen, and still a near collision event happens, and because of that some other satellite has to maneuver, the question then is, can the satellite which maneuvered get compensation or any other reparation from the satellite because of which it had to maneuver? I know it's a complicated problem, but to put it very simply, the question is the satellite which maneuvered because of a near collision event, because another satellite came near it, should it be allowed to get compensation or any other form of reparation? The answer is yes, it should be, and it should be able to do that because Articles of State Responsibility, which are general rules of responsibility, does apply to space. Of course, it is modified by Article 6 of the Outer Space Treaty. But then, if the responsibility is breached, then of course, there is a reparation that is incurred. And a state has the responsibility to ensure that it does not create near collision events and which leads other state to maneuver. And why do we say that the state has that responsibility? Part of it flows from a due regard principle, which is there in Article 9 of the Outer Space Treaty, which says that states should act in due regard to the corresponding interests of other states. So, and also one should remember that in any case, Outer Space Treaty, which has been signed by 112 states, it basically states that any action, the freedom of use and exploration of outer space should be for the benefit of all, and it should not be violating others' rights to explore and use. So if a state satellite, and when I say state, I mean states, both governmental as well as non-governmental entities, create a condition which leads to a near conjuncting event with another satellite. In that case, the the state which satellite has created that situation should be responsible and responsible, and from that responsibility should be and can be asked to pay compensation or any other form of reparation. So basically what I'm trying to say is the primary obligation that flows from Article 9 and Article 1 of the Outer Space Treaty, the primary obligation of not creating a conjuncting event or ensuring that a conjuncting event does not happen, that lies under Article 9 and Article 1 of the Outer Space Treaty. And then there's a secondary obligation where the responsibility arises under Article 6, read with the Articles of Responsibility, which was drafted by the ILC. Now, if that is done, if this is recognized, I think that will go a long way in proving it easier to have mega constellations, because mega constellations are necessary and important. But because of mega constellations, other satellites, which belong to smaller states, they cannot keep maneuvering themselves, and the onus should not be on them to maneuver. We should remember that maneuvering costs fuel, and fuel is expensive, and using up the expensive fuel can reduce the lifespan of a satellite. So it's important to recognize that whereas mega constellations are important, the interests of other satellites should also be protected. And this is perhaps one of the ways we can protect the spirit of the Outer Space Treaty and Article 1 of the Outer Space Treaty, which states that outer space should be explored for the benefit of all. Thank you.